job to help guard them from harm and neglect, physical and financial abuse, from isolation, from improper medication, and from indifferent care. But now, out of necessity, I practice compassionate use law. And the question that is at issue here today is the city of San Diego ready to declare these citizens criminals? Apparently they are. This city is going to force ill people to make the choice between suffering the physical agonies of illness and engaging in criminal conduct, risking arrest and jail time to get their medicine. The refusal of the city of San Diego to abide by the Compassionate Use Act opens the door to civil litigation by legitimate, qualified compassionate use patients for the denial of their right to safely and legally obtain medically necessary palliative care. Some people compare this fight to legitimize compassionate use to the civil rights movement, but I believe it involves a stronger right of even more greater legal significance and stronger constitutional protections. I believe the Compassionate Use Act protects not a civil right, but a fundamental one. Fundamental rights are those with which each of us is born in the context of a legal system such as the United States. The system itself is based upon these fundamental rights without presumption, without cost of privilege. These rights belong to all human beings under U.S. jurisdiction. And the three fundamental rights that are at the heart of a compassionate use dispute are the right to pursue happiness, professional accomplishment, personal fulfillment, basic comforts, and human contentment, to which we may surely add the right to effective palliative medical care. The second right is the right to equal protection under the law. And the third right in the compassionate use dispute is the right to vote.
Hello.
The Compassionate Use Act, now codified in the Health and Safety Code, does not legalize marijuana. What the Act does is offer a select group of legitimate, qualified patients a right of exemption to use medical marijuana. To paraphrase Supreme Court Justice Scalia, the Constitution says what it says, and it doesn't say what it does not say. Those powers not enumerated to the federal government are the exclusive reserved powers of the state, and health matters have always been the historic purview of the states. Further, the Compassionate Use Act was passed by the initiative process by the people of California. It cannot now be overturned, abridged, or disallowed by California's legislature. The Equal Protection Clause says that no state shall deny any person within its jurisdiction the equal protection of the laws. It empowers the judiciary to enforce these principles against the states. The state is being unconstitutional in denying the First Amendment right to equality of life.
Get a real job!
And now, the city has called in the federal government to arrest compassionate users. And I understand why. It's an election year. The voting citizens of San Diego have shown through the referendum, which effectively removed the city's council ordinance, because it was less regulation than was a functional ban. But I understand the position of the city attorney and the city council. Their city's broke. They don't have enough money to take down all the dispensaries in the city, so they thought they'd go to the federal government to do a little economic house cleaning.
Hey, yo, fuck that.